continue. So I'm going to turn the program over to Maggie Grover, the 2022 Employment Section President, and for Employment Laws Update. Thank you, Maggie.
Thank you. And let's see if I can share my screen here. But before I actually get started, I'd like to invite anybody who is listening and attending today to consider joining the Employment Section Board. We're a pretty fun group. We haven't met in person in a while, except we did have a little cocktail party last year, thanks to Anjuli, which was great. And I'm hoping that in another month or 2 or 4, we will be again meeting in person. We meet once a month. We alternate in person and Zoom meetings when we're in real life. And we could use new ideas. Even if you don't want to spend time on the board, if you've got ideas for programs you'd like to see, send them to me, give me a call and chat. If you've got anything, if you've got questions about whether you're interested or what the commitments are, give me a call. Best number to reach me. I'll put in the chat later on after I'm done talking. So here we are talking about new employment laws for 2022. And of course, it was working before. I swear it was working before. There we go. The biggest new employment law is one that covers settlement agreements. And it covers settlement agreements and severance agreements. And what it says is you can't shut up an employee who wants to talk about unlawful acts by putting a confidentiality provision in the settlement agreement. You cannot prevent the employee or former employee from disclosing facts regarding harassment, discrimination, or other unlawful conduct. And this was initially part of an outgrowth of the Me Too movement. It's much broader now. Other unlawful conduct is tested by whether the employee or former employee has a reason to believe the conduct is unlawful. And so what that means is if the employee has brought a claim and legitimately believes the conduct is unlawful, even if the employer is saying, we did nothing wrong, you misunderstand the laws, and our behavior was completely lawful, you cannot have the employee in a position where they can't talk about it. So that's great for situations where there really has been ongoing harassment. I have some concerns that it's going to make employers want to pay less in settlement, because one of the reasons that employers settle the cases is so they don't get bad press. So I think it will remain to be seen what happens in terms of the value of cases as a result of this law. You can include a non-disparagement provision, but because a non-disparagement provision could prohibit somebody from saying bad things about the employer, the non-disparagement provision must include a caveat. There's particular language in the statute, but basically it says, nothing in this non-disparagement provision is going to prevent you from talking about harassment, discrimination, or other unlawful conduct. So that's the big thing that you have to include in your settlement agreements, the big change. Now, there are, oh good, I cannot spell conversalt. I prepared this way too quickly, apparently. There are other terms that you have to include in a settlement or settlement agreement. One is the notice of right to consult, not consult, an attorney. And you also have to give the employee a reasonable time to sign. The statute says a reasonable time is at least 5 days. And so you can give them longer than that. For example, if you've got a claim with an age discrimination claim included, or an employee who's over 40 and could possibly have an age discrimination claim, most attorneys include the Age Discrimination in Employment Act, Older Workers Benefit Protection Act language that says they have 21 days to consider it, but it's waivable. In this case, The employee may sign before the 5 days or whatever time you are giving them to consider, just like the Older Workers Benefit Protection Act. The statute expressly says that the employer cannot induce the employee to sign earlier by fraud or misrepresentation. The employer may not induce the employee to sign earlier by threatening to withdraw the offer prior to the window for consideration. And the employee may not provide others with better terms for signing earlier. I think the implication is you can say to the employee, hey, if you sign today, I'll give you an extra $1,000 because that's the employee and that's additional consideration. But I'm not sure that's the best practice because someone is going to say that that's some kind of unlawful undue pressure to sign. I generally advise employers just sit back and wait. There are times where you know the employee is squirrely and you just want to get it signed. It's not going to help if you do anything to pressure them to sign in fewer than 5 days. I don't know what's going to happen if there's a mediation, whether the mediator can provide that buffer. I don't know if you are in a court settlement conference. I know that I had one ADA case, ADEA age discrimination case where the employees tried to undo the settlement, saying that the language, the 21 days was not provided and the revocation was not provided. There was a definite choice not to provide it. And the magistrate who ran the settlement conference decided that she was able to provide the necessary buffer and it was a valid agreement and the court was not going to undo it. So you may have some protections in those situations, but I would follow the statute if you possibly can. There are some limited abilities to maintain confidentiality. You can still mandate that the amount that you're paying in settlement is confidential. And if you already have trade secrets and confidential business information, you can protect it. The statute explains the trade secrets and confidential business information will be able to be protected. I have some doubts as to whether you can protect something retroactively if you've not said, hey, this is a confidential information or this is a trade secret. So, yeah, hopefully you've got those, the employer's got those terms in place if they want to protect something and you can reference back to an agreement. But if you've got things that are important to your business, are trade secrets, you may want to try to build that into a settlement agreement. The statute says you can do that. So health and safety, there have been a few changes. One is for the California Family Rights Act. As of last year, it applies to employers with 5 or more employees. A lot of people are still not really absorbing that. But the change for this year is parents-in-law are now family members. And so if your employee, an employee needs to take time off to care for her mother-in-law, she can do that. Father-in-law, those are within the protected class in the scope of the act. Funny how California, when the Federal Family Leave Act came in, California wanted to match it exactly, except for the pregnancy disability leave. Every year now, we are moving away farther from the federal law, and we'll be back to a completely different law in California in another 5 years if it keeps going this way. The other health and safety laws that came up are some clarification of the COVID notice requirements. If an employer learns that people in a work site have potentially been exposed to COVID, the employer must give notice to all of the employees within 1 business day of learning of the potential exposure. The notice must be given in English and the language of the majority of the workers. So if you've got a Spanish or Tagalog speaking workforce, you need to give the notice in those languages. If you don't have somebody who is capable of writing the notice, you might want to get one prepared in advance, because right now it looks like lots of workplaces are getting exposure. The method of delivery has to be reasonably anticipated to be received within a business day. If you communicate by email, send it by email. If you've got a construction site, put it up, post it, and hand it out. And the notice must explain what the employer's cleaning and disinfection plan is. Another kind of notice, if you have any positive test in the workplace, you have to give workers' compensation notice of the test. In certain circumstances, if you've got a pod of infection, then future infections could become an on-the-job illness, so that your employees are entitled to workers' compensation benefits if they need to take time off. The other notice that is required is to OSHA. If the COVID case is has the terms, the triggers that require OSHA notification, which are death, medical treatment beyond first aid, and or days off. And I think that quarantine, if you've got an employee who is positive test and you're quarantined and you're making them stay away, then that's days off. If you've got people who are remotely working and not needing more than a box of Kleenex and continue to do their job, it's not an OSHA notice. If you have to give notice to OSHA, you include it on your log 300 report. Another thing that is not really a new statute, but is an outgrowth of the statute that was effective theoretically on January 1, 2019, is the change in arbitration agreements. The statute was to become effective in 2019. It was stayed by the federal district court before it really became effective. In September of last year, the statute was reinstated, and the court said, you know, it's been in effect since 2019, so we don't think the Federal Arbitration Act is going to preclude a law that addresses the making of an arbitration agreement. It applies only to the enforcement of an arbitration agreement, so you can't force your employees to sign a mandatory arbitration agreement to get a job. Since that decision, the Chamber of Commerce has requested on-bank rehearing. There was a very sharply worded minority opinion in the September decision, and the Chamber of Commerce is predicting that there will be another 2 years of litigation before there is a decision, even as to whether there will be an on-bank rehearing. I think it'll probably happen a little faster than that. But this leaves a question for employers about what they want to do. Some employers have decided they're going to proceed with mandatory arbitration agreements for new employees. Some are putting caveats saying, you know, here's an arbitration agreement. We'd like you to sign it, but you don't have to. We think it's good for both of us. And they try to sell it. And then they have a box where the employee says, yes, I like this, or no, I reject it. And still others are saying, oh, this is too much of a hassle. We're not going to bother asking our employees to arbitrate. So what you want to do depends on whether you think that the eventual result, after all appeals have come and gone, is going to be in favor of allowing mandatory arbitration agreements or rejecting mandatory pre-dispute arbitration agreements. And a lot of little bitty things to talk about. A new law requires employment records, applications, referrals, personnel files, and membership records to be kept for 4 years. There is always a question about what constitutes an application. If you accept applications randomly and actually consider them as an employer, I think that becomes an application. So if the employer doesn't want to have to keep those every random submission for 4 years, then the employer should say an application is made through our website or is made in response to a particular job or has some other way of defining application. There has been a law on the books for a couple of years that California employers must provide a retirement savings plan. I think that a lot of employers have not really taken advantage really taken notice of this. I think this year it starts to cover small employers. They have to have their plan set up by June 30, 2022. And small employers are the ones that are least likely to have a 401k, which would satisfy this mandatory retirement savings plan. The employer has to provide it. The employees must be enrolled automatically, but they may opt out. The employer doesn't have to make any contributions. And there is a state website that is set up, a state program that's set up, and I'll give you the website for it it's Cal Savers. And Cal Savers, if you enroll in Cal Savers, they will do all of the paperwork. You don't have to have a 401k plan if you don't want to. That can create some headaches. This gives the employees the ability to decide how much they want to put in with every paycheck, how they want to make the investments, and the employer doesn't have to do anything more than sign up. And that's probably the best bet for most small employers who don't already have a 401k. Be aware of state and local minimum wage increases. Richmond has one of the highest minimum wages in the Bay Area. So there you have it. And then there are a lot of industry specific requirements that I don't really have time to go into today because it's time to turn it over to Marta and Anjuli. And
Thanks, Maggie. I'll actually take over next.
Okay.
So that was a great summary. I wanted to just talk about or touch upon something on the health and safety front. So all employers in California are required to have a COVID-19 prevention plan, as well as an injury and illness prevention plan. The DIR's website has lots of guidance and FAQs on the requirements for the plan and has a model template plan that is fairly user-friendly. The big surprise, if you haven't seen what it looks like, is that the model plan is very detailed and covers a lot of areas of a facility's operations that may not have been considered up to the present. So it's certainly worth getting up to speed and reviewing injury and illness plans and taking a look at the COVID-19 prevention plan that the state has issued as a template. I also wanted to touch upon two additional statutory new statutes. Senate Bill 657 became effective January 1st, 2022. And this Senate bill relates to an employer's notice posting obligations. And so for those notices that employers are required to post or provide in their workplace, they are now permitted to send emails in illicit e-signatures for receipt and confirmation of such notices. The Senate bill reflects the reality of a growing remote workforce.
Interestingly, though, let me just add to that. You're still going to have to send out all the federal notices by paper copy.
Yeah, so this is a California state rule only with respect to California state and California agency notices in the workplace. I also wanted to quickly touch upon a new statute regarding wage and hour violations. Assembly Bill 1003 makes a company liable for intentional theft of wages. And that has always been the case, but this new Assembly bill increases the penalty to grand theft. And this is a new section that's added to the criminal code, and it relates only to intentional, fraudulent, or knowing withholding of wages that are known due to an employee. So just wanted y'all to take a quick note of that. Next, I'm going to dive into case law and as it relates to wage and hour issues in California. The first case I'm going to talk about is Farah v. Lowe's. This is a California Supreme Court decision regarding employer liability for missed meal, rest, or recovery breaks in the workplace. The court unanimously held that employers must pay premium payments to employees for missed rest, meal, or recovery breaks at the employee's regular rate of pay instead of their base hourly rate, which many employers were using. So what does this mean? The regular rate of pay versus the base hourly rate. Well, the regular rate of pay can be higher for workers who receive other types of compensation, such as non-discretionary bonuses or other incentive payments, like commissions. So this is an important reminder for employers that they've got to be careful in calculating the amount of wages that they're paying for meal premiums, and they have to take into account all other forms of discretionary compensation that's being paid to that particular employee for that particular pay period. And that will be how the regular rate of pay for premium payments is determined. The facts of this case are pretty straightforward. Lowe's is a hotel, and this case relates to Lowe's Hollywood Hotel, and they employed Jessica Farah as a bartender and paid her hourly wages as well as quarterly non-discretionary incentive payments. Lowe's had a policy that if an hourly employee like Jessica did not receive a compliant meal or rest break, they would be owed an hour of premium pay at their base hourly rate. However, Lowe's had not included in the base hourly rate the incentive payments that were paid to Jessica. And so the court held that, as I summarized before, that the rate of premium pay has to be based on all of the compensation that employee receives in that pay period. It is a reminder for employers to vigilantly comply with meal and rest break rules and to be careful to use the correct formula. So additional training might be needed to make sure that all compensation is included and the appropriate rate is used. Employers should also review their policies, review their meal period waivers, and potentially consider auditing their workforce to see if any violations have occurred in the past, and consider whether or not to issue restitution payments for violations in the past. That would be for the purpose of deterring lawsuits and future liability. This decision was a big decision. It's a California Supreme Court decision, and counsels for plaintiffs have definitely focused in on the rates of or violations for failure to pay the correct rate for premium wages, and we can expect to see more claims being filed based on the decision in this lawsuit for incorrect or unpaid meal premiums. I'm going to segue into PAGA now and talk about a few PAGA cases that have come through the courts in California over the course of the year. So the first case, and if you give me one moment, I'm going to try and share my screen. Okay, maybe not. So I'm going to talk about two cases. The first case is Maxim. Johnson v. Maxim Healthcare. And in this case, the court considered whether an individual who had time-barred claims, meaning stale claims, could serve as a PAGA representative and in the action and recover on behalf of himself and the other PAGA class members. This was an issue of first impression for the courts. You might be reminded of the case Kim v. Raines, where the Supreme Court held that an employee who settles claims could still serve as a PAGA representative. But the court had not considered whether an employee who had time-barred claims could also be a representative. In this case, the California Court of Appeal held that the employee with those time-barred claims could still pursue a representative PAGA claim, and that individual would also be considered an aggrieved employee as part of the PAGA class. So this case expands the scope of who can be a PAGA representative. Again, it broadens and strengthens the ruling in Kim v. Raines. However, this is also a very fact-specific case, and Johnson was a current employee who had argued a continuing violation doctrine, meaning that although his claims were determined to be time-barred, he still had an argument that the company had continued to violate claims. So this may have limited application, but it's still an important decision to consider when looking at whether an individual is a proper representative for a PAGA class. The next case is Wesson v. Staples. It's also a California Court of Appeals case. And this is also regarding PAGA. In Wesson, a store manager of Staples filed a suit against Staples, asserting a PAGA claim on behalf of himself and 345 other current and former general managers. The case was a PAGA case, so it was based on labor code violations, and also had claims for misclassification. This case received a lot of press, and you might have heard about it because it was the first ruling that I think defendants might have viewed, or defense bar might have viewed as a win for employers. The court held that the particular claims asserted by Wesson were unmanageable. And because they were unmanageable, those claims could be dismissed. Now, these claims were dismissed pre-certification. And so it was an early dismissal of the PAGA claims based on unmanageability. The case is fact-specific and also involves some key admissions from the plaintiff that I think swayed the court to strike the claims. The first key admission or concession was that the plaintiff said, well, this case, if we would take, almost 8 years to litigate, and they didn't really have a trial plan in place that could allow the court to meaningfully resolve the case within a reasonable period of time. So although this case is fact specific, it's a reminder that plaintiffs bringing PAGA cases, especially large PAGA cases, should have a trial plan in place that addresses all of the issues in the case, as well as the anticipated affirmative defenses that an employer may raise, such as unmanageability of the PAGA class. And it's also important, to structure a case so that, to the extent possible, so that the trial court can resolve the case meaningfully within a short period of time. The next case that I'm going to talk about is Gunther versus Alaska Airlines. So this involves a flight attendant who brought a PAGA action against the airline for failure to failure by the employer to provide itemized wage statements to herself and other employees. The case involves a lot of different facts, and actually there were many issues decided, but the key holding was that consistent with prior courts, employees filing PAGA actions are entitled to the default penalty. And it's the first time that the Court of Appeal expressly endorsed this type of interpretation with respect to PAGA penalties. And that's the default penalty versus the heightened penalties. The last case I'm going to talk about is Donahue versus AMN. This is a California Supreme Court decision about meal periods and rounding time policies. So many employers in California use rounding policies to round time punches or hours worked by their employees. Well, in this case, A&M had employed a rounding policy that rounded, meaning it just changed in the time system the employees' clock in and clock out times for their meal break. It turned out that employees who were clocking in for less than 30 minutes were not receiving meal period premiums because the time records show that they were in fact getting their full compliant 30-minute meal period. And so in Donahue, the court clarified that although employers can use rounding in general, rounding may not be applied to meal periods. And it's consistent with the statute, the labor code statute, and agency interpretations, as well as the legislative history, which clearly indicates that it's intended that employees are given a full 30 minutes of uninterrupted time for their meal breaks and uninterrupted time for the rest breaks as well. So rounding is really contradictory to all of that legislative intent and industry guidance. The lesson here is for employers to review timekeeping policies and make sure that accurate start and stop times for meal periods are accurately tracked and carefully reviewed. Of course, this is more important for employers that are using rounding in their time systems. It's also important to potentially review policies and train workforce on, when meal breaks should be taken, and that in most cases employees are entitled to the 30-minute uninterrupted meal period, and that they've got to accurately record their time and report any violations if they believe one has occurred. And I will pass it now to Marta.
Thank you, Anjuli. I just want to let everybody know while I'm trying to share my screen that we will answer questions that you put into the chat or the Q&A after my bit. And do you all see the first page?
Looks good.
Yeah, all right, okay. So I'm going to talk about 8 notable cases of 2021 in the non-wage and hour context. This is how we divided it up, and I hope I will not bore you to death. So let's talk a little bit about my little favorite Antislap. As many of you, or I'm sure all of you know, retaliation cases in the context of peer review are often facing an anti-SLAPP motion right away, because the peer review by the medical community of a hospital, for example, is considered to be free speech and also public participation to ensure patient safety and a high quality of medical care. But the facts of this case are kind of mind-boggling. So I'm going to take you back to law school, and we are going to have 8 case notes. So the facts here are that Bonnie was a surgeon, an OBGYN surgeon, who complained after several botched surgeries that the robotic surgical assistants that he was required to work with malfunctioned and that caused adverse patient outcomes. After these adverse patient outcomes, he was suspended and got negative reviews due to these outcomes. Later, he was terminated. Then he filed a case saying this is retaliation based on the healthcare whistleblower statute, and got immediately an anti-SLAPP motion because the hospital argued that the entire process of peer review, including his termination, was protected activity under the anti-SLAPP. So California Supreme Court was facing this issue and did a really good analysis of how the anti-SLAPP procedure goes and what needs to be taken into account. So this case is super useful for that. But the particular issue that they were looking at was what types of retaliatory conduct alleged by the doctor is subject to the dismissal under the anti-SLAPP statute. Is this the entire peer review and the termination and the suspension, or just particular parts of it? The court held that while some of the forms of retaliation, the statements, the free speech statements, are protected activity under this statute and can be struck from the pleadings, the retaliatory discipline does not get struck. So the fact that the physician was then terminated is not going to be struck from the complaint, and the case was allowed to continue. While the hospital may seek to strike some of the physician's retaliation claims, the hospital was not entitled to wholesale dismissal of those claims under the anti-SLAPP statute. Now we are moving on to Fija. So there was an interesting case about aiding and abetting, and I think it could have been pleaded better by the plaintiff, and then this would not have been the outcome. But it may have been a test case to test the limits of the Fija aiding and abetting doctrine. So this is another hair-raising fact scenario. Jiffy Lube, a Jiffy Lube branch or franchise owner had a representative of BP Lubricants come to make a presentation to the entire service staff on how to use Castrol products. And the presenter then proceeded to basically humiliate one of the African-American participants in this training. And there were 3 African-Americans and 47 whites or non-African-Americans, and they were all laughing delightfully. And the 3 Black people were like, this is not funny. And the plaintiff sued, alleging that the presenter aided and abetted the race discrimination that he was facing at the employer, but did not sue Jiffy Lube for discrimination. It was just an aiding and abetting claim, and made an Unruh Act and an IIED claims against the presenter. So we have 2 cards, 2 slides about this case. One of them is the aiding and abetting, and then we will return to the Unruh Act and IIED claims in the next slide. So as to the aiding and abetting, the court held that the plaintiff has to prove that the employer subjected them to discrimination and harassment. He alleged this, and that the person accused of aiding and abetting knew that that the employer had this conduct that violated Fija. So they had to have known about it and had to have aided with substantial assistance or encouragement to the employer to violate the Fija. And these second and third requirements were not met by the plaintiff here. I think if he pleaded that that discrimination against Jiffy Lube itself or against the franchise owner, then he would have succeeded probably with the aiding and abetting case. As to the Unruh Act and IIED, the issue was whether these three statements made in this one presentation are just this garden variety, you know, we are not a civility code type of comments, or they raise to the level, the threshold level of where the Unruh Act and IIED can be claimed. And the court unequivocally held that yes, these three statements made by the presenter, and I encourage you to read the case for how awful they were. One of them was, for example, he said, "I don't see your eyes," you basically implying that he's too dark and like not visible in the room. And then another one was he called his hands banana hands. So just like awful statements can be a basis of an Unruh Act and also of an IIED claim, which is interesting. In some other contexts, the courts require much, much higher outrageousness of the conduct for IIED, but racially insensitive comments can land someone in court faster than, say, in Quidditch. Okay, let's go to wrongful termination, mitigation of damages. Martinez v. Rite Aid Corporation is a case that was just going on and on and on. The case was filed originally in 2008, and there was a trial and there were damages. And then Rite Aid appealed, and the basic verdict of culpability was upheld, but damages were tossed back to the trial court for retrial. So there was a second trial, and the jury came back with even higher damages than in the first case, $2 million on Ms. Martinez's wrongful termination claim and $4 million on her claim for IIED jointly against Rite Aid and the supervisor. And the issue, the only issue that the Court of Appeal basically threw back to the trial court was whether wages earned from a job that the plaintiff took up after she was terminated can be deducted from the damages award, the past economic damages award, because the plaintiff claimed that they should not be deducted because they were from an inferior job. And there were prior court cases that were precedential in this case that held that if the plaintiff declines an inferior job, then the defendant is not entitled to deduct those wages that the plaintiff would have earned. There's a lot of would haves here, I'm sorry, but such is the law. So here, because she took a job that was arguably inferior to the position that she would have filled if she continued on in her employment with Rite Aid, those earnings, though, are actual mitigation of her damages, and they are reducing the past economic damages award. So it went from $320,000 or so minus $140,000 were deducted, but in every other aspect, the verdict in favor of this employee who filed this case in 2008 were affirmed. And continuing with the theme of damages, let's talk a little bit about garden variety emotional distress. In this case, this is such a fun case, Briley versus City of West Covina, only 2 hours from the beach, if you remember, from Crazy Ex-Girlfriend. The facts of this case are kind of hair-raising too. Here is a fire marshal who was terminated after he reported corruption by his supervisor. And then the supervisors were elevated to even higher positions. So by the time he would have had an appeal hearing, they would have been the decision makers in his appeal hearing under the civil service rules. So a lot of the appeal discussion involved whether he exhausted administrative remedies, because by the time the case went on this appeal, he decided that continuing with his civil service appeal would have been futile, because he's going up against, he's arguing his case that his supervisor was corrupt to the supervisor himself. How is that going to play out? And so a lot of this case involved that aspect. That actually was affirmed, but his damages were reduced by the appellate court, or if he doesn't accept this reduction, then it will be retried for the damages. And the issue was, what is an appropriate award? And there were some statements made by plaintiff's counsel in the closing arguments, which may have activated some passion on behalf of or on the side of the jury, that resulted in this $3.5 million emotional distress damage, when the plaintiff never, I said he saw some counselor once or twice. There was no documentation of any medical attention, and he just stated that he experienced a lot of, self-confidence issue type of stress and lack of sleep and insomnia, etc. Basically the gamut of emotions anyone would experience when they are suddenly out of a job and they have teenage kids that they need to support. So because of this lack of documentation, lack of support for his emotional distress damages, the court thought that the $3.5 million emotional distress damages was shockingly disproportionate and reduced it to 1.1 million. Okay, next. Fee shifting under Fair Employment and Housing Act. So
Marta, we've got about 8 minutes left, so maybe 5 minutes and then a couple, 3 for questions.
Okay, I'm going to talk faster, or just in a monotone. I'm just going to read down my slides. So here, the employer prevailed on a motion to compel arbitration and then asked for attorney's fees based on the arbitration agreement, which allowed for attorney's fees for whoever prevails on the arbitration agreement's enforcement. The court, though, applied the Fija fee shifting mechanism, in which attorney's fees to the prevailing party are only, the prevailing defendant are only allowed if the losing plaintiff was absolutely groundless in litigating whether the arbitration agreement should be enforced or not. So there is a lot of quotations. You guys can read it on your own time. Administrative exhaustion under the Fija. This was a little bit of form over function argument, but if you haven't heard it all yet, or you haven't tried it all, here the plaintiff filed Human Chevrolet DBA Human Enterprises Inc. In her Fija complaint, but the employer actually was MBA Automotive Inc. DBA Human Chevrolet of Culver City. Based on this disparity, the employer claimed that there was no ground for this Fija claim, or it should have been thrown out because they failed to exhaust administrative remedies. This argument was rejected. Again, beautiful quotations. Age discrimination, stray remarks. In this case, the The plaintiff was opposing a motion for summary judgment and relied on a declaration by another former employee who said, not regarding the plaintiff's promotion, but somebody else's hiring decision, that we wanted someone younger for that position. That declaration was objected to on several grounds, and the trial court sustained those objections and dismissed the case. The appeal court reversed and said these stray remarks were definitely not hearsay. None of the other objections, they are highly relevant. Two other objections were kind of nonsensical, and that even one stray comment is sufficient to evidence with other evidence submitted by the plaintiff that there is a general discriminatory animus on the part of the employer, and the case will survive summary judgment motion. The final case is Maynard v. Dignity Health. I also encourage you to read this case because it's quite interesting. I often say, you know, easy cases make bad law, but there is a little bit of thing in this case that kind of is interesting. So Maynard was one of three researchers working with a doctor, and his job was to get the grants that will get them all paid for their research. And he was really, really successful and got really high remarks, excellent performance evaluations. But then he had a little bit of a court case when he was charged of child abuse. And the court kind of makes this point in the case. And I don't know how much this kind of affects the court's view on the plaintiff and on this case, and also that this is only an environment in which there are three scientists and potentially only one job. So after this little court case that the plaintiff had, he was agreed to a plea bargain and was required to stay in Texas and could not move when the project was moved to Arizona. So everybody moved to Arizona except him. He stays and works remotely from Texas. But once he stays remotely in Texas, after his little court case, everything goes to hell in a handbasket, and they are not getting the grants. So they first fired the other male researcher who files a grievance, and there is an investigation. And the grievance is filed because this other worker said that the boss is sleeping with a female scientist and gives her all sorts of privileges and favors her. And here I am terminated when there is lack of funding, and this female is not. And in this investigation, our plaintiff in the case that we are going to talk about says nothing about this. So later, though, when he is terminated, he says, now, wait a second, I am terminated now, and the lover of my boss is not. Now, the employer also submitted a lot of documentation showing that the girlfriend of the boss is actually highly effective and an amazing employee. But for us, the issue is whether this paramour preferential treatment is discrimination because of sex. And the Ninth Circuit went along with the other circuits that already held that preference given to somebody because they have a sexual relationship with the supervisor is not discrimination because of sex, it's discrimination or because of her sexual activity, maybe, and sex and sexual activity are distinguished from sex as an immutable characteristic. And it just, the case did not just pan out because if our plaintiff was female, he would still not be the female sleeping with the boss. And so it is not discrimination because of sex, it's discrimination because of this preferential treatment due to her sexual activity with the boss. I think this is strange, but the court kind of stated that the EEOC's view that widespread sexual favoritism still may be grounds for a sex discrimination case because it demeans women in the workplace is still a good theory, but just not when it's just one boss, one paramour, and one employee being fired. I think the case was also weakened by our plaintiff here not making the same complaint when the other male coworker was terminated, and said nothing about the affair that the boss and this female researcher were carrying out quite openly. So these are my cards. And if you have any questions, let's see if I'm going to stop share. Let's see if you have any questions for me. Wow, on the dot.
Well, and we have actually,
15
Ann
more,
told me
yeah.
we have 15 minutes left. So we've got 2 questions in the chat and I'm only temporarily unmuted. So, all right. So the first question in the chat, these are both out of my presentation, so I will answer them slowly and let people start typing with questions for Marta and Anjuli. We have a question: does the new settlement law bar employers from requiring employees to keep confidential the amount of the settlement? And in California, the state law allows you to include a provision that prohibits the employee from discussing the amount of the settlement. That was true in the 2019 law that came around specifically dealing with sexual harassment settlements, and it's true in this new law. The interesting question is what happens under federal law, because there was a Tax Reform Act that included language that said something to the effect of, if you include in a sexual harassment settlement agreement any non-disclosure provision, there is no tax deductibility for attorney's fees. And I've seen discussion about whether that applies to plaintiff's attorney's fees or only defense attorney's fees. That may have changed to apply only to the defense attorney's fees, but make sure you get tax advice in the sexual harassment area before you settle a sexual harassment case and include any kind of confidentiality provision, including one that addresses the fees. The next question that we got was, does every settlement agreement need a representation that the employee or former employee can consult counsel? And that really is a 2-part answer. The terms of the new statute talk about any settlement or separation agreement that includes ending the employment. So if you are settling a case that is just ongoing harassment and the person is still employed, that would not seem to be covered. If you are settling a wage only case, that would not seem to be covered. However, if you settle the wage only case and ask the person to step down, or you settled that ongoing harassment case and ask the person to step down, that would be covered. There is also language that says the section does not apply to a negotiated settlement to resolve an underlying claim that's been filed in court, before an administrative agency, in an ADR setting, or through an employer's internal complaint process. But the negotiated language says it has to be voluntary, deliberate, and informed, provide valuable consideration to the employee, and give the employee notice and an opportunity to retain an attorney or actually be represented by an attorney. I have heard people comment on it that you can't have a negotiated settlement if the employee or the employee's attorney says that's not negotiable, that you could not then force in the confidentiality provision. I am expecting that I will see in mediations defense counsel coming to me and saying, if you want to settle this case, it will be $100,000 to settle if there is included a confidentiality provision, but $40,000 if there's not a confidentiality provision. And I think it's going to be a very difficult negotiation the first time I get that. But that would be, there would definitely be something given in exchange for that confidentiality. And I think that that would allow you to have a confidentiality provision. There are commentators out there that are saying there's no way you can do it. So how it plays out, it's going to be interesting to see. What other questions do we have? I don't hear any little tip tapping and I don't see anything popping up. Marta, do you have any bad jokes to wake them up?
Ooh, unfortunately, I'm logged in the house with, I only have dad jokes. Whatever my,
Wow,
whatever
bad
my
jokes.
husband-
Way to set her up, Maggie. Nice.
Yeah, I know. I promise that my jokes are gonna be lame.
Do we
So-
have anyone in our audience that is part of the retail industry or the warehousing industry where you've got warehouse distribution workers or the food app industry? If you do, raise your hand. Maybe we can quickly touch upon some of that industry specific guidance.
Oh, I've got a couple of warehouses in my client base.
So for warehouse employers with 100 or more employees, there's a new law that requires disclosures of quotas for those workers and written requirements describing what the quotas are, meaning how much production is required, and what happens if you don't meet a quota is now going to be enforced. Quota for warehouse employers that don't have these quotas in place, they have to quickly develop written quota plans and make sure that any quotas that are imposed on warehouse workers are compliant with the meal, rest, and health and safety laws.
All right.
Well,
I'm-
Maggie, did you see the note in the chat from Andrea? This is going to be very interesting. We should go ahead and plan for a year-end program on the impact of the new laws and the settlement agreements.
Mhm.
I did see
I think
that.
Andrea wants to be on the board.
I know Andrea's on another board, but I was going to call her and ask her offline.
There we go. Well, I
Well,
just
She's
set
not
that
going
one
to take
up.
my calls.
All right, everybody.